Well, good morning, everyone. Thank you very much to the organizers and sponsors and to Jacob for inviting me to this event. Let me front at this top. I'm not a technical person. I think if my children knew that I was up here talking to a room like this, they would find it endlessly humorous. At home, I'm not allowed to use the remote control. So I don't know that, but what I do know is I know Department of Justice. I spent over 20 years with DOJ. I have extensive contacts in DC at the US Attorney's offices around the country and with the federal agencies that drive these investigations. And in talking to Jacob, it seemed like the time had arrived to talk with a group like this a little bit about sort of what approach is being taken by Department of Justice. And the top line is, I can say, working with DOD, there's a certain amount of impatience and frustration and even exasperation, I think, about how long it's taking to drive compliance. And we'll talk about how that's playing out in some of the cases. But at the same time, I want to recognize that the False Claims Act is not about honest mistakes. You know, and that's, I teach at law schools with some frequency explaining what the False Claims Act is. And I think it's important to recognize that, and it's being enforced and applied by thoughtful, reasonable people. But it's an important area right now, as I think the government has gone out of its way to explain, and we'll go through how that's playing out. So this thing, the False Claims Act, it's sometimes referred to as Lincoln's Law. And don't worry, I'm not going to take people back to a lot of 19th century history, but I think there is something significant about where it emerged from and where it's being applied going forward. And specifically that it came from military spending. It came from a recognition that in the Civil War, with military spending, there was an unacceptably high level of dishonesty and fraud against the government. And so Congress put together this set of laws that we've come to know as the False Claims Act to incentivize people to come forward and let the government know that there was fraud going on, and also to incentivize those people financially. That if the government made recoveries, a share would be awarded to whoever it was who had brought the situation to the government's attention. These cases are sometimes known as key TAM cases. That's a phrase you might have heard. That takes us a little further back. Key TAM is this idea that it's a Latin phrase, but who speaks for the king can also speak for themselves. What's important about this is, as we'll look at some of the cases going forward, this set of laws, the False Claims Act and the whistleblower provisions, were also intended to enable taxpayers to have a say and to have a voice in how their money was being spent, and if it was being misspent or misappropriate, they could play a role in getting it back. And it is easy sometimes with the amounts of money that move through some of the federal budgets to lose sight of the fact that we are talking about taxpayer money. And you'll see references to that come up as we look at some of the individual cases. So the original False Claims Act was meant to punish and deter fraud and to incentivize whistleblowers. These formulas have been revised significantly, and we'll look at as what's gone into that, but those goals remain true through the program up through today. Now, there was a time actually where Congress backed off of the enforcement of the False Claims Act. And it's interesting, again, we're talking about military spending, World War II, and in the wake of that, there actually was sort of a decline for both within the Department of Justice and the agencies, how much time they wanted to spend on these False Claims Act cases. They were concerned about what they referred to as parasitic lawsuits, where the government already knew what was going on. They didn't need a private actor coming in. And so there was a lot of discussion about how to bar for prior knowledge by the government. And along with that, they reduced the incentives. But what happened then, as some people in the room may actually remember in the mid-'80s, early '80s, sort of all these headlines about profligate costs and spending within DOD. The proverbial $640 toilet seat or the $436 hammer or I think there was one about the AWACS, the stools that they had in the AWACS that had these little plastic caps on the legs of the stools, and the government was being charged $1,400, for something that cost 4 cents. And as that made its way through Congress, it actually led to a reinvigoration of the False Claims Act, which happened in 1986. And it did and continues to draw support, bipartisan support. It's one of the maybe rare things that continues to do that. Signed into law by President Reagan. And as this slide indicates, 2 things. Once they wanted to increase the incentives for whistleblowers. Some of that's financial, but there's a different portion that I want to talk to you all about as well. And make it easier to punish or deter fraud. And this is an interesting quote from Senator Grassley from Iowa, and he has been one of the main proponents and defenders of the False Claims Act, but this idea that going after waste, fraud, and abuse without whistleblowers is about as useful as harvesting an acre of corn with a pair of rusty old scissors. The kind of direct wisdom that comes from the Iowa farmland. But I think what's going on there is the recognition that to get into where these activities are taking place, to get the information on a timely basis for the government, you need to have whistleblowers as an integral part of this whole enforcement structure. And that's going to be true for the Civil Cybersecurity Fraud Initiative, to be sure. That's not the only area, but it's going to be one of the priorities for DOJ. And as they implement this program, whistleblowers will continue to play a very important role in bringing the cases to the government's attention. So with these amendments we talked about now, successful whistleblowers in the modern era are entitled to anywhere between 15% to 30% of the government's recovery. And we'll talk in a minute about how the government, as Jason indicated, how they calculate those recoveries. And they also decided that they needed to adjust a little bit about government knowledge. This was an interesting discussion, debate in Congress, but at the end of the day, they made a very deliberate decision that, yes, it's important that the government might have its own investigations, but they did not want to disincentivize private individuals, employees, insiders to come forward with information about significant fraud. So they sort of changed a little bit of this government knowledge bar in favor of private citizens with information. These 2 other areas at the bottom also became important parts of the program. Retaliation protection for whistleblowers. That's a significant piece of this entire set of laws. The False Claims Act itself has a separate provision about retaliation, and a number of state laws now do as well. And we're going to talk a little bit about DOD has its own specific regulations to protect whistleblowers in their employment situation. And there can be claims, and there can sometimes be very significant claims. For individuals who tried to bring these gaps, right, these non-compliance issues up through the senior levels of management, and instead of being recognized or applauded for doing that, they actually get retaliated against in workplace, up to including termination. And that's a concern for the people who drafted the law. It's a concern in the courts, and it can lead to some parallel and significant recoveries for the individual whistleblowers. And then finally, there's also a provision that where the defendants, if they're found liable for one of these false claims situations, they are actually required to pay the attorney's fees of the whistleblower herself or himself. So with this era that we're in now, one of the things that Congress has done with the current version of the False Claims Act is they wanted to clarify what it meant to knowingly, and we'll talk where knowingly shows up, but what is this, like, knowingly present a false claim or a false document to the government in order to get paid? So there's actual knowledge, which is straightforward. And that is happening. I mean, we have cases, and we're continuing to work on cases where it's pretty brazen what gets said sometimes about people inside the company knowing, well, we're not in compliance, but how likely is it we'll ever get caught? You know, those are conversations that are happening. So there you get actual knowledge. But under this law, you can also be held liable if there's a demonstration that there's deliberate indifference or conscious avoidance. And those are actually, as you can see, much more flexible terms. I mean, it's with these headlines, and they are trying to drive, I think the media coverage, they being DOJ and DOD, I mean, it's hard to believe that there are people in the defense industrial base who don't have some knowledge of what these cybersecurity, NIST 1-800 controls are. But those days are over of just claiming we didn't really realize that this was an important facet of our government contracting work. And that's being pointed to again and again in these DOJ press releases. And now we're going to talk, here, when the False Claims Act is applied, and it is viewed as the most significant tool that the government has to deter fraud and punish fraud, the way it's written is the government is entitled to treble damages for the loss that the government incurred. And the penalties per event, per claim, they peg that to the cost of living increases. So now I think it's between $13,000 and $27,000. You can all see there'll be situations where in carrying out, performing a government contract, there's just one claim after another claim after another claim, and each one of these, in theory, can bring its own penalty, financial penalty. We've handled a lot of cases in the healthcare fraud area, a lot of cases with the pharmaceutical companies. That's certainly an area where we've seen, because of the system that's set up for reimbursement through CMS, the penalties, because each one of these medicines, each one of these medical devices has a billing moment, those penalties can get extremely high. And so here's just the overall summary of where we are today from these 86 amendments to the False Claims Act. There are definitely more resources and more whistleblowers. The volume of cases, and we'll take a look at that, has gone up significantly and steadily. There's more money being collected from defendants, and there's more money being paid to whistleblowers. Here's one way of summarizing sort of that steady increase in what we're seeing in money being, as the slide indicates, being returned to taxpayers, because that's where most of this money is going. It's going back into the federal budget, into the budgets of these agencies, participating agencies. So in application now, the False Claims Act is touching a lot of programs. For a while, I would say for most of the last 25 years, the largest, most significant cases were being driven out of the healthcare area. We may be seeing a little bit of a transition. We'll see, not necessarily because they've achieved complete compliance in healthcare, but I think there's now this new focus on defense procurement, defense contracting, and cybersecurity. That cybersecurity piece, incidentally, I think is going to spread back to a number of other areas of federal procurement, but the defense industry, for better or worse, is going to be the front edge of that. So how does it actually work? How do these false claims cases actually come into existence, and what's the life cycle as they move through the court system? And that is an important part of it. We work with other agencies, SEC, CFTC, FinCEN. They have their own administrative whistleblower programs, but that's directly into the agency itself. What makes the False Claims Act different, and it's intentionally different, is that the whistleblower, or in the way he or she is referred to, the relator, they actually file a case with the district court. And now the court is going to be part of this process as well. And so, we spent a lot of our time drafting these complaints with and for our clients. We file them, but what's important is we file them under seal. So they are not part of the public docket. And that was set up to give the government chance to move forward with its investigation before there was any public record that they were looking at a certain company, a certain defendant for a certain course of conduct. So we put together these complaints, anywhere between 30 and 60 pages typically, that it lays out for the government the elements of what happened factually, but also how this violates the different provisions of the False Claims Act. Then with that, as we formally serve it on the government, we also provide what's known as a mandatory disclosure statement. And we spend a lot of time on those as well, because what we're trying to do is give the government as much of a running start in these investigations as possible. So we're trying to summarize, hopefully, what we've been able to locate and organize as the most important documents. Sometimes we don't have the documents, but what we do have is the information from the insider who can narrate, here's where all the documents are, here's where all the records are. As you know, every business, every organization often has its own acronyms, its own abbreviations. So having someone on the inside who can say, no, there's a report that's prepared every month, this is what it's called, this is where it's stored, can be hugely advantageous to the government as they go out and begin collecting the evidence. And they do that typically through subpoena. All the agencies have subpoena power, and certainly DOJ has subpoena power. I'm not going to talk a lot today, but anytime you get Department of Justice involved, yes, there's a civil component. There's also potentially a criminal component. There are discussions going on as these cases come in, different offices around the country and different agencies. They are taking a look at, does the knowledge here and the conduct here actually rise all the way up to a criminal case? And I've had relators, I've represented people who come in on the civil side and have their information, but in the end, the government has decided this is serious enough, and I've had clients collect evidence for agencies, under agency supervision, record calls, make monetary transfers of government funds, set up face-to-face meetings with targets who then get arrested. I mean, it can morph or move back and forth between the criminal and the civil. But we'll stick with the civil and explain a little bit. So the government gets this information. We're also trying to give them as much witness information as possible, let them know who else out there is knowledgeable about the underlying facts, how you can get a hold of them. In these investigations, there's often, initially, there's often sort of a priority if there are other former employees. With some of these organizations, there are a lot of former employees. That is, that this path got walked a number of times where individuals tried internally to get senior management focused on this. This is an issue and it needs to be addressed. And again, rather than getting supported, they actually get terminated. And it's not infrequent for me in these cases that the person I'm talking to knows of at least 2 or 3 prior people who left not under the best of circumstances. And those are individuals that you can imagine the government's going to be very interested in talking to. It sort of builds a chronology. It builds a pattern. Each one of them has their own set of conversations, communications within the organization. So that can be very important as well. But as the government does this, it takes a while, and each 6 months or so, they're going into the court to ask to extend the seal and explain to the court, we're working on this investigation. Again, back in healthcare with some of these big national kickback schemes, those investigations can last 4 to 6 years. What we're noticing on these cyber security fraud cases, though, is that the timeline is accelerated. That could be, in part, the resources that the agencies and DOJ are putting into them. It could be because there's an ability to demonstrate the violations earlier, in the investigation and begin discussions with the companies about some kind of resolution, some kind of negotiated settlement. But in the Morse case, for instance, that moved in approximately 2 years, which is very quick for the typical federal False Claims Act case. Once the government reaches a point, most of these cases do settle. Not all of them, and we'll talk about that in a minute, but when the government knows that there's going to be a settlement, then they move to unseal. They tell the district court, we want this matter now part of the public record. And then very soon thereafter, or at the same time, they'll be filing notices of the settlement with the defendants, which obviously have been worked out over months leading up to that date. There are times, though, that cases get unsealed and there is no settlement. Georgia Tech is one of those matters, where it's going to be more of a typical litigated civil case. And I believe Georgia Tech just moved into mediation, I think court-ordered mediation, down the northern district of Florida, or excuse me, of Georgia. So that will be interesting to sort of watch how that progresses. But underneath in these cases, there's also the ability, if the government decides for one reason or another we're not moving forward, because we filed the case as the relator, we do move forward sometimes. Now, just to be clear, that's not something we do without a lot of analysis and without a lot of discussion with the government about, well, what did they find that made them decide not to pursue this case? And in many situations, because the government has access to far more information through its investigation, subpoena power, we have conversations with our clients, and that's kind of the end of the case. But there are times where the government says to us, actually, we think this is a valid case. We just don't have the resources right now to devote to it. And so at any given time, for instance, in my firm, we probably have anywhere between 2 and 5 cases that are in open litigation that's handled in more of a traditional civil litigation, depositions, interrogatories, summary judgment motions. It's rare for these cases to go all the way to trial, but it does happen, and there have been some very large trial verdicts in the last 2 years. Not all of them go successfully, but the ones that do tend to capture the headlines. One in New Jersey that it's going to run into the billions of dollars against one of the major pharmaceutical companies, and one up in Minnesota that involved devices for ophthalmologists that, again, comes close to $500 million at the end. That's not the typical case, everyone. That's not the typical case, but it's out there as far as how the defendants are evaluating the risk of pushing some of these claims all the way. And I think myself and a number of people in this practice space, who spent a lot of time in court along the way doing trials, we have sort of a feeling that once you get this in front of a jury of taxpayers and explain what's going on here, they tend to see the process, they see the system, and they are holding these companies accountable. So this is just letting you see a little bit. I won't go on and on about this, but where that you can find the False Claims Act within the U.S. Code, and this idea that it's meant to address and deter knowingly presenting or causing to present a false or fraudulent claim for payment or approval. I think that causing to present is going to become a little bit more of the landscape here on some of the subcontractors. I think we're still watching to see how those cases work their way through, but I think for some of the subs that maybe have got a little bit more relaxed about certifying annually that they are in NIST compliance, and then in turn that gets presented up to DOD. I think that is an area that we're going to see some activity on. The make use false records or statements, you can certainly see situations where the SPRS scores could fall under that section. We saw it a lot in the healthcare area, with hospitals, cost reports, over delivery of services, over billing of services. So it wasn't that it had never taken place. It was it just wasn't necessary, and they falsified records about, let's say, a class of patients' medical necessity in order to pave the way for overbilling the government. The False Claims Act does have a component for conspiracy. When I was a criminal prosecutor, it was rare for me to have an indictment that didn't have a conspiracy count in it. And so I became very familiar and very comfortable with the whole presenting conspiracy and the federal rules of evidence that go with that. I will say in the civil side, there's a little bit more hesitation from the courts in particular about invoking conspiracy for litigative False Claims Act cases. But it's in there, and I think it's in there for a reason. So you can see how applying to any given situation, there may be actors at more than one organization who the government feels worked together, agreed and conspired with one another, let's say, to defraud the government as far as seeking and obtaining payment for performing contract terms, or performing contracts that were not actually performed in accordance with the governing terms were. So that's out there. And then the last one, just while we're all here talking about the False Claims Act, is this idea, what's sometimes referred to as a reverse false claim. So you got government money, let's say in a contract, you got overpaid, and once you realized you were overpaid, you didn't give it back. So Congress did add this to say, I think it's a 60-day. You have 60 days to give the money back once you realized we weren't entitled to this. And after that, it becomes a reverse false claim. You're keeping money that you weren't entitled to. It also gets applied just while we're all here in customs cases. So customs is one of those areas where they rely on the participants filing accurate statements with CBP about, well, here's what's coming in country of origin, what the duty rates are and whatnot. And obviously, with what's been going on recently, knowing what the duty rates are can be quite a challenge. But if customs finds that you systematically underpaid your customs duties, and that does happen, they can use this provision that you kept money that really should have come to the government, and it's known as a reverse false claim. So within the False Claims Act, we talked a little bit about knowledge earlier, that this is a, if you're knowingly making false claims to the government for payment, are you deliberately ignorant of what the provisions are? Are you willfully blind to what those provisions are? And so the Georgia Tech complaint is an important one for us all to look at, because this is the government now coming into the litigation itself, filing their own complaint and intervention, and they're going to lay out what they consider to be the most important pieces of demonstrating knowledge on behalf of the defendant. Georgia Tech, it's a number of different entities within Georgia Tech that have been named in that particular action. But they certainly, they being the government, wanted to highlight there was an awareness of noncompliance. They also make reference to some of the deliberate ignorance or reckless disregard. And Georgia Tech is an entity, the scale of it and how far some of that knowledge moves up to the highest levels of management, maybe somewhat of an outlier compared to the typical DIB member. But they certainly put that, they being the government, put that in there for a reason, that they're expecting even senior management to be aware that this is an important issue and that they can't pretend that they don't realize or they don't know what these requirements are. Another thing they pointed out is, that they felt that Georgia Tech continued to bill despite knowledge that they were out of compliance, and they failed to report breaches. And that certainly is an important consideration that's going to run through these cases. Was there a breach? And as you all know, there's a whole protocol upon discovery of a breach of how that needs to be reported and how soon it needs to be reported and where it needs to be reported. So this is one of those areas where I'm sensing elevated frustration within the government enforcement groups of not reporting these. They just feel like there's no excuse anymore. And that's a discrete fact that can and I think will continue to drive the government's position as they move through these investigations. And then there's this idea, is it material, right? So how important was this really to the government? And that's gotten a lot of play healthcare-wise. Like, anyone who's ever tried to read the Medicare or Medicaid regulations, it goes on and on and on. And there are times between DOJ, and in that case it's Health and Human Services, where there's a feeling like, well, this company didn't follow some of these regulations, some of these statutory provisions. But Health and Human Services occasionally will say, you know what, that's not that important to us. Not true with this area, just to be clear. So, they're using Georgia Tech, and these settlement agreements we'll look at as we go forward, to say, like, this NIST compliance is material. And that's, when DOJ says something like that, they would only say that with full support from DOD, that at the highest levels between those two agencies, that discussion has taken place, and it's just baked into the landscape now that compliance is material. There was, as you get into a little bit more of the facts of Georgia Tech case, there was a discussion about misrepresentations of the quality and the content, other things that probably seem pretty straightforward on fulfilling the requirements. But this is another interesting one that DOJ alleged that they would not have alleged without DOD saying, we'll stand behind that, which is, hey, if we had known about the non-compliance, we would not have paid you. And that's an important moment, in this rollout, in this effort, in the dialogue between DOD on the one hand and DOJ on the other, is DOD is going to take that position at the highest levels. So we talked a little bit before, there are treble damages. How that gets applied in these, some of these military supply vending contracts is still to be determined, I have to say. And I've been on panels with the senior people in DOJ who are implementing this, and they admit it's still to be determined. There are different ways of sort of peeling this onion, and we'll talk about what we're seeing in these cases. But treble damages can be a significant amount. We talked about the penalties as well, and then the whistleblower is entitled to get their expenses, costs, and their attorney's fees paid. And the way that works in application, where the government has intervened, and that's most of these cases, the whistleblower is entitled to between 15 and 25% of the government's recovery. When they decline, and we've had those cases as well, where we've litigated it, in that case, our client is entitled to between 25 and 30%. Look, and there are exceptions to this, common sense ones. Like, what they don't want is the main actor in creating the fraud sort of circling back around and then somehow getting a lottery ticket at the end. Like, no one wants that. We certainly don't want to represent those people. You see that every now and then. Like, there's been some in the tax IRS program where some of the people who themselves kind of created these bogus tax shelter, and then they think, once they've made all the money they can make off of that, maybe they'll come back to IRS, turn all their friends in and get money off of that. IRS doesn't want that, the courts don't want that, and we don't want that either. So there are exceptions. There is this retaliation provision, and this does belong to the relator personally. It's not the government's claim, it's our client's claim. There's an extensive way that these cases, these retaliation claims get pled and resolved. But one of the things to be aware of is they stretched it out to prevent former employees from blackballing, former employers from blackballing their employees going forward looking for future employment. So that can be its own actionable damage. But before we leave this False Claims Act case, also to reconfirm, look, when they wrote this, Congress said there needs to be some barrier to just throwing these cases, which are serious allegations, out there without, if they turn out to be frivolous, there needs to be a consequence, and there is. So the defendants also have the right to recover their reasonable attorney's fees if they prevail in the action and the court finds that the person who brought the action, that the action itself was clearly frivolous, clearly vexatious, or brought for the purposes of harassment. So that is built in as well. It's not just open season. You need to be sure of what these claims are and that they're legitimate. So how has that been starting to get run through these various cybersecurity fraud cases and the controls that you all have lived, I know, for quite a number of years? And in 2021, the then Deputy Attorney General made this very public pronouncement about companies choosing silence under the mistaken belief it was less risky than to come forward and report. And that changes today. As part of that announcement, there is the Deputy Attorney General who specifically said we're going to use the False Claims Act, and we're going to use the False Claims Act because of its unique whistleblower provisions. So that's the second highest official in the Department of Justice, clearly sending out a message to individual whistleblowers: we want you to come forward and tell us when there are companies that are not following the cybersecurity requirements in their DoD contracts. So how's DOJ calculating these damages is very much an open question, but one of the things that cannot be ruled out is value of the contract. That's obviously can be a staggeringly high amount. I don't think they'll do that. I haven't seen them come close to that yet, but bear in mind there are other programs out there where, for instance, certain set-asides for veterans-owned businesses. So there may be a company that's not really veterans-owned. They fulfill the contract terms. They deliver the goods that the government asked for at the price they asked for, but they actually defrauded the program because they weren't veterans-owned. And there are cases, and the courts have backed up, saying, no, you have to give all the money back. The government was hiring a company, that fell within this particular program, and if you didn't, you have to return all the money. I don't think that's going to happen in these cases, but there's a corollary there, and we'll look at one of the statements where I think there's an appreciation at DOJ. Compliance takes effort, it takes resources, it takes time, and it takes money, and they don't want to see companies that do that lose a competitive advantage to companies that don't do that. That is at the forefront of what these people within DOJ are thinking as they're applying, as picking up individual cases and taking them to settlement. So there's a possibility that they'll actually invoke that value of contract in maybe some of the most extreme cases. And finally, there needs to be some recognition here that there is credit for self-reporting. The Verizon case is probably the single largest one to date. I'm anticipating there'll be more coming, where a vendor, a contractor who comes forward on sort of a clean slate and lets the government know, actually there have been problems here. For Verizon, it's not a small amount of money. I think it's a little over $4 million, but for Verizon, it was a small amount of money. And we can look at some of the other cases. I'm just anticipating these numbers will continue to grow. I think that for both because they being at DOJ are looking to calibrate what amounts of money it takes to really drive compliance across the industry. And a number of the senior people at Department of Justice who are handling and overseeing these cases, they came from healthcare fraud. And some of them are used to some pretty big numbers as what they see at the end of the day. So I'm anticipating these will go up. It was interesting, I'm sure, for all of you as well. Raytheon, which just came out last week, didn't move quite the way I would have anticipated, given the profile of the defendant. I think there may be some case-specific facts there with efforts by the defendant to at least alert the government to some of the gaps. And that the complaint reads a little bit more as a personal retaliation than a programmatic fraud case, but these are still multi-millions of dollars, and for many participants in the defense industrial base, I mean, these are critical, potentially very critical amounts. So for Morse, the sort of the four legs of the table that Morse got resolved on and that we're seeing now in a number of these other cases, and I think everyone should anticipate, they're looking at is the company using non-compliant cloud-based services. That appears to be an ongoing issue for a lot of DIB parties. Certainly, the government found it was an issue there with Morse. The second one can cover a multitude, obviously, of activities, but this idea that a company failed to implement the NIST 800-171 controls, failed to fully implement a system security plan. This one is going to be everywhere. This one we're seeing virtually in every case, and this idea that you need to define the boundaries here of the systems, monitor them, limit access to them, report if there have been intrusions, and then build in a way to update, as necessary and keep it current. Over the horizon, once there's more compliance on that, I think we're going to see more emphasis as well on marking and on training as part of implementation of SSPs. And then there's the posting of an inaccurate SPRS score and the failure to update once the party knows that it actually was not accurate. So that was an important issue in Morse. Yes, they posted an updated SPRS score, but it was only after they received a subpoena from the Department of Justice. So in announcing that result to the larger world, the U.S. Attorney in Boston, where that case was filed, used the result as an opportunity to make statements about what's important to her office and to DOJ. But again, that she went out of her way, right, to ensure that federal agencies and taxpayers, right, so there's that phrase that sort of lies at the heart of the False Claims Act, get what they paid for. And the second clause, which I think is important for everyone who's taken the time and put the effort and resources into being at events like this, is to make sure that contractors who follow the rules are not at a competitive disadvantage. So that is a statement that was made with a fair amount of thought, and it's meant to send a message out to the larger defense industrial base. And here you get a separate quote from the special agent in charge of that region of DCIS. And what we're hearing is these results, these cases are starting to drive sort of the deployment of resources across these various agencies. That as they see results, they're going to continue to increase their participation in these investigations. I think what's going on right now is a fair amount of informal task forces between between FBI, DCIS, HSI. NASA has started to become a much more active player in this space. But I think my own personal speculation is that you're going to see those task forces becoming just part of the landscape. Georgia Tech, again, is going to track some of these with no SSSP, a false SPRS score. I thought this was interesting that there's this allegation of a culture of cybersecurity noncompliance. That gets a little bit towards what I started with, that there's some frustration here with these agencies that are just sort of in disbelief that, in this case, an entity as large and sophisticated as Georgia Tech thinks that they can just opt out of compliance if it's too cumbersome. There is this myth that an intrusion event is sort of a necessary. It is not necessary. I've seen a number of these cases where there was no documented intrusion. Obviously, if there's no SSP in place, there may be a reason there's no documented intrusion event. You don't need to point to that. It's always helpful if you can, but you don't need to. We looked a little bit at these numbers before. I just want to flag that DoD is not just out on its own for these cybersecurity initiatives. It's coming other places. SEC has done more and more of its own rulemaking in this space. And, you know, I know some of the people out of this SEC cyber group as well, and I went to one of their events, and I thought it was interesting. One of their more experienced enforcement attorneys made a remark, you know, saying, look, cybersecurity, it doesn't work for the C-suite people to say, you know, I don't know, that's what the guys in the hoodies who drink Red Bull, like they're in charge of all that. And they made it clear for the SEC, that is not acceptable. You know, these senior levels of management need to be conversant and fluent in this, and they need to know if there are gaps. There are a few others. New York Department of Financial Services, you know, given where the financial industry tends to cluster, they can have an outsized impact. I thought it was interesting. They actually require companies there to appoint a CISO. And it's coming, the QE or CUI stuff is coming across the FARS. I'm going to move through this as far as how we look at cases, because I want to make sure I do a little Q&A. But you know, that's the more balanced. This is the reality of what I spent a lot of my time doing, which is talking to this guy. I got a lot of calls from this guy. So they're out there, you know, and there is often that, there's that risk with certain people who are self-appointed whistleblowers, that they see things in the world no one else does. So I understand that, DOJ understands that. I'm going to circle back. It's not about honest mistakes, but this is a program where the government's put enormous resources into informing the participants, you know, setting deadlines, making sure everyone knows about them, and they now they're serious about actual compliance. So let me stop there, Jason, or Jacob, I'm sorry, and maybe move to questions.
Mike's walking around. We also have a tremendous number of questions that came in from people streaming online. So if you could keep your questions short and to the point, that would be great. Does anybody have questions here in person before we get started? We'll go ahead and kick off with some of the online questions. Oh, Ryan's got a question right there. And then we'll go to online. And raise your hand just so we can queue you up if anybody's got questions here in person.
So in these types of complaints or cases, how much of the overall progress in a false claims prosecution relies on like these documented decisions by individual actors saying like, no, we're not going to do these compliant things? And how much of it can still be built on there is a system that rewards noncompliance?
So for the first part of that question, I think it's helpful to have those documented moments where there are a lot of these email back and forth, you know, where people are saying, we know that, but we're not going to, you know, for one reason or another. It's a business risk. If we followed every rule, we can never get anything done, you know, things of that nature. But it's out there, you know, it's baked into the whole contracting world is by submitting these bids over a number of years now, you are implicitly saying we're going to follow all this. You know, we're going to follow these cybersecurity requirements. So even in the absence, I think, of one discrete exchange, these are still viable cases. And I'm sorry, the second part of the question, I apologize for.
It was how much reward for just general non-compliance systems that don't enforce it versus individual.
Yeah, you know, there's going to be a priority here of looking for the strongest cases, particularly in these initial months and years of application. And so, you know, in our firm, we're screening out over 97% of the cases that come in we don't move forward on. And that would include a certain number of cybersecurity cases where there really isn't discrete evidence. And yes, I saw that reference, everyone else did too, a culture of noncompliance. But if someone came to me with just, you know, this company has a culture of noncompliance, that's not a case I would put my time into. You I think that there needs to be more discrete evidence.
Questions that came in online. Somebody said, what if I, the IT guy, am told to upload an SPRS score that I know is not accurate? Am I liable if I do it?
Realistically, I don't see DOJ going after individuals who sort of are following orders within an organization. I think they would see that as counterproductive to the overall mission of what they're trying to achieve. But I have had a number of clients who fall into that exact category, and I think everyone has to do their own cost-benefit analysis, but coming forward as a whistleblower, whether you want to file a False Claims Act case, whether you want to simply use, each one of these agencies has their own reporting mechanism, if you want to just go right to them, is a very good way of making sure that you are a witness throughout the whole process. That you're the one who came forward and told the government, this happened, it wasn't correct, and I want you to know it. Many of those people, on their own accord, decide this is not an organization I want to be with anymore for obvious reasons. People with those skill sets can often find alternative employment. So I haven't seen that yet. I guess it can't be ruled out theoretically, but I just don't see the government going after the individual who simply posted it because they were basically required to by a more senior person in the organization.
Okay, another one from online. Is there a statute of limitations on FCA violations?
Yes, there is a statute of limitations on False Claims Act cases. It's pretty, we're nowhere close to that yet. I mean, it's 6 years. A lot of these cases, the activity is over time. And obviously SPRS scores need to be reposted. So that's its own, you can reset the clock there from time to time. And we talked a little bit about conspiracy. That can stretch it back even longer. And I have seen in settlements, there are settlements that are rolling through DOJ right now that capture activity that goes back to 2002. The government has the wherewithal to address it because of the way some of these laws are written. So we're nowhere close to getting to the statute of limitations barrier, but it is part of the larger False Claims Act.
All right, there's a question on the right side over here.
For the 3% of cases your firm does move forward for, I'm curious, what is the threshold, or when is it when you make the decision or say there's something here? What is it you're looking for or your firm is looking for in your discovery process?
Yeah. So the position of the person in the organization, frankly, are they in the room with senior management when these decisions are being made, or better yet, in email contact? Best of all, if they kept the emails. Person's placement, we want to look at the company itself. For instance, candidly, would they be able to even pay a significant, some of this becomes a little bit theoretical for some of these companies. So we want to see if there's going to be the wherewithal, if there's a collectability issue. And the CUI, within everything that could be called CUI, certain programs, certain initiatives are more sensitive than others. We know that. We know from the people in the agencies. So yeah, in the ones that hold with them, the potential for the most damage if this data information is exfiltrated, that's a factor we look at as well. And I want to also underscore that there are cases that we get where we don't see them as right for us, but we work very hard to get the information into the right hands. So in healthcare fraud, there are occasional, there's patient harm. It's not a case that works economically for us, but one of the things I have is a whole network of contacts, in the state AG's offices, in the agencies to get information so it can be acted on. Similarly, in this world, it started to come up more. There may be elevated security, even well above CUI, which is obviously an enormous concern. And I did national security cases for a while. I had those clearances. I don't have them today. I make it very clear I don't want to know any of the details. But for clients or prospective clients who come in, where that we might be talking about, things that are TS or above. I know how to tell the government to convene the people they need to convene. They can get that information in a controlled, secure environment with people with the right clearances, and they can make the decisions they need to make.
We got one in person. See if I can get over there in time. All right, so we'll do one last one online and then one in person. The question online was, how does whistleblowing and non-retaliation intersect with employee confidentiality and non-disclosure agreements?
Yeah, that is such an important question, and I meant to get to it. There's a specific rider, thanks to Senator Grassley, in the National Defense Authorization Act that tells defense contractors you cannot use non-disclosure agreements to limit your employees' ability to lawfully report fraud, waste, or abuse to DoD. That's its own standalone violation. And I'll tell you on the SEC side, every year the SEC goes after companies, not because necessarily they did anything wrong, but because they're using employment documents, separation agreements, severance agreements that restrict the employee's ability to report, in that case, serious financial misconduct to the SEC. So DoD has that as well. I haven't seen a standalone enforcement action yet against a company for misusing non-disclosure agreements, but I think it's going to be used as an aggravating factor in some of these cases, is my guess. So that's the most obvious, to my eye, interplay between NDAs and the ability to report as a whistleblower.
Okay, last question right here in front.
I was just curious if you know what percentage of the whistleblowers are usually within the company that they're whistleblowing against, or another company or another agency?
Yeah. So most whistleblowers, and the best whistleblowers, in my personal opinion, are insiders. People who are percipient witnesses who lived it and can explain it to the government in the clearest terms. We do see cases where competitors will report against each other. And some of those cases have been not insignificant. I mean, it's a little bit easier to see healthcare. Company A has a drug, and they're losing all their market share to Company B, and they found out, hey, Company B is out there bribing doctors to choose that drug. And that has happened, and it does happen. And in that situation, the government sometimes is, they're sympathetic to letting a competitor come in and be the whistleblower. There's a group out there who are just sort of professional whistleblowers. We try not to work with those people. Don't get me wrong, I mean, I have colleagues I respect a great deal who have practices that are a little bit more open to that. I'm not. I think some of those cases, particularly in the SEC world, there are people who are outsiders. I worry sometimes, they've shorted the stock, and now they're going to try and strategically use the whistleblowing process to see if they can't drive a change in the value. I think that's really dangerous, personally, and I think it's contrary to what we're trying to accomplish through whistleblowing. But I have colleagues who have a higher risk tolerance on that than I do.
Okay, well, thank you, Bruce.
Great, thanks,
thank you
everyone.
very much. I appreciate that.
Thank you.